Please, my lords. My lords, I beg to appear in this matter. May I?
Just a minute, madam. आपकी bail reject हो गई? Your bail application has been rejected.
Before the lower court,
Please,
yes,
my
Your Honor.
lords.
Before the lower court, yes.
So, why have you not challenged that against that order? Why
My
have you
lords,
not filed it?
we are in the process of challenging that, but this
So you take
petition
that
has.
process, madam. You take that process.
So, my lords, but this is a very serious matter. May I just
Yes,
bring
we
to your
know that
notice?
is the serious matter.
May I just bring to your notice few facts here?
Ah.
My lords, my learned colleague there has the application for remand, and that becomes very relevant. Now, an NBW order which is under challenge before my lords is, my lords, it's been taken only on that they require me for some investigation. There is not a whisper in the application that any kind of summons have been issued to me at any time or any detail of any of those summons requiring me to join the investigation. It is completely silent. My lords will even see that application for remand also. It does not mention that there was any kind of a thing that I was not appearing or I wasn't there. Now, it is quietly, it's very well settled that if you want to take an NBW against me, at least you have to issue summons, you have to ask me to join. In this case, nothing has been issued at all. My lords, number two, at this stage when an NBW is issued against me, I am neither an accused nor I am evading arrest. Now, my lords may take section 75 of the DNSS for a minute, please, with me.
Just a minute, madam. Just where is the order issuing non-voluntary challenge here? Kya?
Yes, my lord. I have been challenged.
Where
Yes,
is
my
order?
lord. Page number 31, my lords. My lords, at 32. Page 31. My lords may come to the relevant portion at 32. My lords, my learned colleague is there. May I request him to just read it out for you, please?
Just we will ourselves read it out. Don't worry about it.
My lords, 32, the top two paragraphs.
Just,
will be.
just, madam.
Yes, I'm sorry. I apologize.
Yes, madam. बताइए.
Now, my lords, my learned colleague present there has the application that was filed. Even in the application, it's completely bereft. There are no specifics, no details, which summons, when was I called. In fact, it was not even the case of prosecution that there was an apprehension of me absconding or farar hone ka. The application does not mention any of that. Now, my lords, what is very significant is that this FIR is of 14 January 24. Now, in 1.5 years, they have not deemed it fit to call me at any time. They have filed a charge sheet and 2 supplementary charge sheets. I may have been named in the FIR, but in all the 3 charge sheets that have been filed, I have not been named. So therefore, at this stage, I am not an accused. Now, in this connection, please come to section 75 of the BNSS with me. NBWs could have been only issued, my lords, if I was an escaped convict, if I was a proclaimed offender, or I was a person who's accused of non-bailable offense. At this stage, I am not an accused at all because I'm not even named in the charge sheet. At any stage.
What about the investigation being pending against you in the charge sheet?
My lords, they have not
You are named
issued.
in the FIR, madam. You are named in the FIR. You say
My
that
lords,
the charge sheet has not.
but
If a
it is-
person, if a investigation pending इनके खिलाफ क्या?
My lords, can I answer that?
जी, please, एक मिनट बताइए. You say that you are named in the FIR, but no charge sheet has been submitted against you. So
Yes,
you
please,
say
my
that
lords.
you are not yet an accused. How
Yes,
can
my
you say
lords.
that you are not an accused? You are named in the FIR. Investigation is pending. Then
So,
how
my
can you
lords,
say that you are
then
not
my
an accused?
submission, then my
जी.
submission for your consideration is this, my lords,
जी.
that if you now this could only be if an accused is evading arrest. If you look at section 75, escaped convict,
75
proclaimed
BNS,
offender,
75 BNS, madam.
my lord, 75, or person who's accused and is evading arrest. There should be 2 components to it.
But
And
here,
if you see-
madam, I will stop you here. Just look at the impugn order. What
But
the
this is
learned
not
judge-
in the application, evading arrest.
No,
That's what I'm
madam.
trying to
You just
say.
maybe that may not be an application, but the court has applied its mind and has quoted the order of the apex court that in what circumstances an arrest warrant can be issued.
So,
If
my
you
lord,
go by section 41 of the CRPC, on mere suspicion, also you can be taken into
my lords,
custody.
I can only say this here,
जी.
that number 1, it is not their case. They only say पूछताछ करनी है. They don't say they want to arrest.
Madam,
That is
you are
their
named in the
application.
FIR. You are named in the FIR. The investigation is pending.
My
You
lords,
say
I
so
have
that
4
for the
points.
last 1.5 year, you did not appear before the investigating officer.
My lords,
Then
there
what
are
does
no
it-
summons. That is my case.
When you are,
My
when
case
you are
is.
madam, when you are named in the FIR, no summons is to be issued. It was only on the
My lords,
apprehension. Also, the police can.
to appear for investigation. My lords, to appear for
Do
investigation,
you have
they
any
have to at
interim
least
order
give
in
me
your
a
favor for
month.
the last 1.5 year? Do you have any interim order anticipatory bail from any
My
court
lords,
of
they
law?
didn't name me in the charge sheet. Why should I have that?
Why,
Why
madam?
should I
Why?
have if I'm
You are named.
Now,
You
my
are
lords,
named already
my
named
lords,
in the
if I may
FIR.
just
The
pause
investigation is pending against you. You say that you are not an accused. How can you say like this? You are an accused
My
in the
lord-
present case. There is an allegation against you
My
also
lords,
in
I
that
want
FIR.
to, my lords, I want to submit this.
Ji,
That
ji.
in the respect of there is other point that I have is the manner in which my arrest has been carried out. Now, in respect of this very same liquor scam, my lords are aware that previous ED investigation, the FIR was quashed by the Supreme Court on 8th of April
We
2024.
have made that exercise a lot. And
Oh,
we
my
have
lords,
also,
just 1 minute.
and we
Bear
have
out
already
with me.
passed an order,
Bear
and
out
probably
with me.
this court's
My
order
lords-
has also been upheld by the Supreme Court.
My lords, no, just, I am not on that. My lords, I have been appearing in those matters. I am not at all on that.
LOC against him.
Just
जी
allow me
जी
a
बताइए,
minute.
प्लीज बताइए
Just-
हाँ.
My case is twofold, if I may make this submission and make myself
First
clear.
of your
My lords,
argument
this
was
is a-
that you are not charge sheeted, though you are named in the FIR, therefore you are not an accused, you
Yes.
cannot be summoned
Now-
because there
now,
is
my
no
lords,
summons has
my-
been issued. Next point, what you want?
Yeah, can I?
जी,
I
next
want to,
बताइए.
my lords, I have 4
And now
points.
you want to
Allow me to
demonstrate
just
before this court regarding the manner in which you have been arrested. The second point, you
arrested.
please
That is
बताइए.
one. Second thing that I want to point out, if I can just complete my first argument, it will only take me 1 minute. My lords, it will be my case that under section 193(9), now there are charge sheets that are filed, charge sheet and 2 supplementary. If the IO wants to carry out further investigation, which is beyond the period of 90 days, he has to then take the permission of the magistrate. It is not the case here at all of the prosecution that they have taken any such permission in which I am required. That is only to persuade my lords to accept my case that as of now, I have not been required. I am not going further than that, but I will make good my argument. So my lords, it is therefore my case that at this stage, when no further investigation can be carried out in terms of 193(9), in charge sheet I have not been
193(9)
of the BNSS.
193(9) of the BNSS.
My lords, it is equivalent to the
further investigation.
It is equivalent to yes, my lords, it's equivalent to 173(8) of the erstwhile CRPC, my lords. And my lords, but there is a proviso that is added to it, and I would request my lords to look at that proviso. My lords, I have 4 points here. I would request you to please allow me. I'm sorry if I'm taking your time, but
please go ahead. Please go ahead.
Very, very kind of you, my lords. Very, very kind. So, my lords, there is a proviso to 193(9), which, if my lords may just look at that, which says, provided further investigation during trial may be permitted with the permission of the court trying the case, and same shall be completed within a period of 90 days, which may be extended with permission of the court. Now, 2 supplementaries have been filed. Thereafter, it is my reason to believe that no such further extension has been taken, so that comes to an end. So, my lords, I'm linking my 75 argument with 193(9) for my lords' permission, this thing. My lords, my second limb on the same thing will be that there is no mention either in the application or in the order that they have issued any summons or how am I evading arrest. It is my case that there is another case which is going on in Raipur, and I have been appearing there, and the last that I've appeared in that case is on 4th of April 2025. So how can it be said that I'm not there, I'm not available? I am at the same place. Number 3, in the same limb of the argument, in this case, my lords, this case, as my lords are aware, is an offshoot of the previous ECIR, which was ECIR number 10. In that matter, ED has already come, that issued me summons. I have responded to it was an ACB summons, I believe. I have responded in writing to those particular summons. I have also annexed that. My lords will find that at page number 73. So my lords, it's not that I'm not joining or I'm not available. I am saying this NBWs are bad. So my lords may turn to page number 73. These were the previous summons that were issued to me.
You first also answered the query of the court. When your bail application has been rejected by the competent court, what stopped you from moving an application for bail before the higher court?
My lords,
this is Article 220. You have an alternative remedy. You have an alternative remedy. You should have moved the bail application. You are already in custody. It is not that you are outside jail and you are challenging that arrest warrant.
My lords, I will rely upon the orders, judgments of the Honorable Supreme Court,
please do so.
where the arrest is bad per se.